Good morning. My name is Evan Ponce and want to welcome you to the webinar on what to consider before hiring your first employee. It's my pleasure to be here on behalf of Pro Bono Partnership of Atlanta to speak to you a bit this morning about this issue of what you as a nonprofit organization should be thinking about if you're thinking about hiring your first employee. Um, I'm an employment lawyer here in Atlanta, and so all I do all day, every day, is help employers deal with their employees. And it's my pleasure to share some of that insight and information with you. And hopefully, this will be something helpful. I'll say at the outset before we get into our information, making a decision to hire an employee or add employees, if you already have one or two, let's say, is very critical to your organization and its mission, because I know from my experience employers spend an awful lot of time with employment issues. Uh, when you've done a good job in making the decisions about to hire and hiring, you spend far less time managing your employees and far more time carrying out your mission. When you don't do such a good job thinking about it, when you don't know what to think about, or you make decisions that aren't ideal, you spend an inordinate amount of time dealing with the fallout of those decisions. So I want to encourage you to uh, think carefully and get help from resources like the Pro Bono Partnership uh, for these situations. So why don't we get going with our program today? First, want to make sure that you're all aware of the mission of Pro Bono Partnership of Atlanta, which is to maximize the impact of pro bono engagement by connecting a network of attorneys, people like me and lots of peers like me here in Atlanta and elsewhere, um, with nonprofits in need of free business legal services. And my aside, my editorial comment is Pro Bono Partnership is an amazing organization. So if you haven't been touched by them beyond things like this webinar, you should. Pro Bono Partnership, there's a little bit of information here, which I won't go over in great detail, but information on eligibility. In order to be a client of Pro Bono Partnership of Atlanta, an organization must be a 501c3, located in the greater Atlanta area or serve that area, serving low-income or disadvantaged individuals, and obviously be unable to afford legal services themselves, or I would imagine it also includes those who affording legal services would greatly interfere with their ability to carry out their mission. So it's not a matter of having no money in the bank, but it is a pro bono organization and it depends on volunteer attorneys and their staff to help the clients. I would encourage you to visit Pro Bono Partnership Atlanta at www.pbpatl.org and learn more about them or get in touch with them and utilize resources they have like webinars like this. Our next slide is just some legal information that you can read, but the key of this is, and we want to make sure everybody does understand this, this is general advice being provided to you. It is not specific legal information for your organization or the situation you're in. If you have specific questions, specific concerns, specific needs, you should reach out to a Pro Bono Partnership or other legal counsel to make sure you get good answers to your specific issues. Relying on general information and hoping it fits your circumstance is not always the best idea. We don't encourage that at all. So hopefully this general information will be helpful to you, will lead you to make good decisions, but when you have specific questions or specific worries or specific legal needs, you should reach out to counsel or an organization like the Pro Bono Partnership to help you. With that, I want to get into the meat of our topic today, which is what should you be thinking about? What are the issues? What are the concerns? What are the pluses and minuses before and during hiring the first employee? And let me start by going over who or what is an employee. I think we all have a common sense notion of what an employee is, but it has different legal meanings in different contexts. There are old historical meanings, there are more modern meanings. In a nutshell, in this day and age, the biggest fact of an employee is someone you as an employer have the right to control. And that's the key factor. Whatever organization might be reviewing your situation or from your own viewpoint, you should be thinking about, do we need and want someone that we have the right to control in lots and lots and lots of detailed ways? And to contrast that, we've all probably dealt with independent contractors or volunteers. To distinguish between employees and those types of folks, volunteers are, as we know, people who've agreed to spend some of their time and energy in service of our organization. While we can tell them what to do, We can ask them to do certain things. In the end, the only right we have over them is to say, go away. If we don't like what they're doing, if they're not following our instructions, we have no more right to say anything other than, you can't volunteer with us anymore. So if they don't listen, if they don't behave, that's the maximum we can do. And if they don't show up when we want them to, if they don't do the things we want them to, we have very little, if any, control over that, other than, again, the only carrot and stick we have is their participation with the organization. Contrast that with an independent contractor. This is someone who is providing services to the organization, but in most situations, they are in some way, shape, or form in business for themselves. They bring some professional knowledge, some unique skills, some special talents that you don't have, and they work for themselves providing services to you. The classic example is the person who paints your house. You're not employing that person. You are having them come provide their painting services. You may tell them you want the house red. You may tell them that you need it done this week, and you may agree on a price. But beyond that, you're not going to instruct them which part of the house to paint first, or which brush stroke to use, or how to tape up the wall before they paint. Those are the things you're going to entrust them to do, because that's why you've hired them, and that's why you're paying them, and you're paying them to get the job done by and large, rather than by the moment or by the hour or by the amount of time that they spend. Contrast that to an employee. An employee works subject to your specific direction. You can tell them what to do, what not to do, how to do it, and get as involved in the details as you want. If you trust them and rely on them to know certain things, then that's great. They can do them. But if you want to tell someone, this is exactly how I want you to do this, first you do A, then you do B, then you do C, then you do D, an employee is required and obligated to follow that. And so that is that right to control that you have with an employee. And obviously you have the positives and negatives to manage that employee. You have the ability to pay them. You control how much you pay them. You have the ability to manage them, to keep them as an employee or end their relationship as an employee. And so you have that right to control, and the exercise of that control adds a lot to the difference between an employee versus someone like an independent contractor or a volunteer. Okay. Now, moving on to the next slide, still talking about who or what is an employee. Employees have certain legal duties and obligations to their employers. They have rights to loyalty. They have obligations to be loyal to their employer, to not take advantage of opportunities that come up in the workplace and use them for themselves rather than their employer, and certain obligations like that. The flip side of that, and this is what we really want to talk about more today, is employers have many, and frankly, many more legal duties to their employees than employees have to their employers. And so it has to be worth it to you as the employer to have the right to control someone to hire them as an employee. If you can get the services you need from them based on their occasional volunteering, if you can farm it out to a contractor and have them provide the services that you need, then it may not be worth it to you to hire an employee and go through all the obligations that having an employee entails. On the other hand, if you can't get what you need from someone who's just at their whim coming to volunteer, or you need more control than you can and should have of an independent contractor, then that might well be a reason to consider hiring an employee. And it's that balance between the value of the right to control an employee versus the obligations that come along with having someone who you call and treat as your employee. And being an organization that exists at the mercy and wonder of its volunteers versus an organization that employs someone is a very big leap and change. And what we want you to be thinking about is, do I want to make that change, and if so, why? So moving on to the next slide, it asks the very simple question: why do you want or need an employee? And you need to think about very seriously, how will having an employee change or benefit my organization? Some organizations are in a situation where they've effectively had employees and they just haven't called them that. They've been treating them as something else. Well, certainly if you're already in that situation, it's appropriate to consider making them employees, treating them properly because you've been getting all the burdens and you haven't been getting the benefits. Um, but if you truly are in a situation where you haven't had any employees and you really have at most volunteers and independent contractors, and now you're really looking at adding an employee, one or more people who are really going to be your employee, think about how that's going to benefit your organization. How do the value that having that person that it creates for the organization, how does that weigh against the risks, the problems that could come up if things don't go perfectly? As I'm sure any of you who know lawyers are aware, lawyers exist sometimes to identify all the problems that can come up. And that's unfortunate. But it's for a good reason, because if you've thought about these problems that could come up, you hopefully can figure out a way to solve them or avoid those risks. If you haven't thought about those problems, you haven't thought about those risks, they become bigger and much more problematic for your organization. And especially for a lot of smaller nonprofits, your budget is small, your resources are small, and the last thing you would want to do is spend an inordinate amount of your time and energy and dollars dealing with an employment issue, because it might very well severely limit or worse, restrict your ability to carry out your mission. If your mission is to serve a certain population or community and you have a limited budget and you to do it, and now you're spending all your time and energy and some of your money on fighting over an employment issue, how are you going to possibly effectively serve the community that you're existing to serve? So you want to make sure that you can see that the benefits of having this employee are going to significantly outweigh any of the risks that you might be taking by having an employee. Consider the timing as well. Is this the right time? Are you ready to have an employee? Not just because you need the work, but because someone is going to be there to exercise that right to control. It doesn't do you any good to hire an employee if no one's there to tell them what to do and how to do it and keep an eye on what they're doing. It's not the goal to simply hand off the work and then the person is never seen, never heard, never dealt with. That's not the way you want to have your employees. That's not a productive, effective way, and it creates a lot more risk. So is the burden of having another person you're responsible for something you're ready to take on? This is a bad analogy. I'll recognize that up front. But it's like a individual or couple getting a pet or having a child in a lot of ways. You have to make sure you're ready for that responsibility because it does bring a lot of responsibilities. It brings a lot of joys and a lot of benefits, but it brings a lot of responsibility to have an employee that you now have to follow a lot of rules and regulations about. You've got to manage and deal with this person, this individual, as well as the work that they do. So you need to seriously think about that. Moving on to the next slide, I think I've laid out here some of the things that you should be thinking more concretely about hiring an employee. If you've reached the conclusion, we really think we need someone else, and we really think we're ready for that, then I still think you need to do a little bit more. You need to think about what are the skills and abilities and characteristics you want in this person, this employee, or any employee you're going to hire. It's not just that this seems like a really great person, because while that's a good factor, that's not enough. You should have an idea of what the successful employee will be doing and accomplishing. What is it that will make you look 6 months or a year or 2 years or 5 years down the road and say, this was a success. This person did what we wanted the employee to do. If you don't clearly have that in mind, you're probably not just ready yet. You need to do that little bit more thinking to say, here's what success for us looks like, so that you can then say, okay, if this is what success for us looks like, what are the skills that person needs, we think, to achieve that success? If you were hiring a grant writer, you said, okay, what our organization needs is to find more grants. And we don't have anybody capable or with the time to do it. So let's hire someone as our employee to write grants. Well, then obviously you would think about what it takes to do that, what skills and backgrounds and abilities it takes to do that, and how much time you want them to do, and how many grants you expect them to apply for in a month or 6 months or a year or a funding cycle or whatever time frame you're considering. You've got to think through that stuff. Too often there are organizations that simply say, this is a good person, they can help us, let's hire them and give them something to do. And while that might work out just fine in a lot of situations, there are others where it won't. or you'll be looking back on that saying, gee, we should have thought this through. And you're better off thinking it through before you start rather than trying to do it on the fly. Consider either at least thinking through and perhaps setting it out a job description, a real listing of what the employee is going to do, the tasks, the obligations, the requirements that you're going to have for the individual. It's not always absolutely required that it be written out and handed to the employee. But if you couldn't sit down and figure out what the employee is supposed to do, you couldn't list off for them or someone else their obligations, their job duties, then you're probably not ready. An employer should be able to sit down and say, okay, this is what this person is supposed to do, whether they have a written job description or not. Written job descriptions can be helpful. The one proviso I would give you is make sure they're complete, make sure they're right, and make sure you update them from time to time. If the job changes, you want the job description to reflect the job that's either being expected or being performed. So the only downside of documentation is your documentation needs to be good and stay modern, stay up with the times. If the job changes, the description should too. So for some employers, you don't need a written job description, or at least not one that necessarily is published and handed out to the employee. But you as the person in charge or your board or whomever should have a concrete, clear idea of what this employee is going to do, what this employee maybe isn't going to do, what limitations or restrictions you want to place on them, or what obligations and duties you want to give to them, what they're going to be responsible for. The more concrete, the more specific, the less subjective, the better. Not all jobs lend themselves to you're going to make 100 widgets a day. We get that. And I'm not expecting that that would be in most job descriptions. But if the job description is making a certain product, that's what would be listed there. And maybe it simply says in an amount as set between the employee and that person's manager over a period of time. That's fine. That number can change, but there should be an expectation that they're going to make at least a certain amount as discussed with their manager. And obviously that's in more of a manufacturing context. Probably none of you listening are manufacturing products. Maybe I'm wrong about that. Most of you probably aren't. But whatever it is you're providing, whatever it is you're doing, you can sit down and either generally or specifically know what the employee should be accomplishing on a daily or weekly or monthly or annual basis and make sure that's part of the job description. Lastly, have you thought about what you're going to offer? Pay, whatever benefits, if any, that you're able to offer them, whatever perks of working with the organization you may be able to offer, and thought through the reasons why someone is going to accept your job. Maybe in a tough economy, that's not as critical of a consideration because there are not people who need and want a job that you'll find someone. But think about the person that you want to hire, the skill set, the abilities, the experiences. Is what you're offering likely to match up with the kind of person that you want to hire and the abilities and experiences that they have? If you're looking for a very senior, very experienced person and you're offering very little, you might get lucky, but that's going to be a lot harder. So you need to think about, are the job you're looking for commensurate with what you're offering? If it turns out that you need someone very skilled or very in demand, and you can't afford that yet, maybe you're not ready to hire and you need to figure out how to raise the funds or generate the funds to have the skilled person. Because if you're looking for a skilled person in demand and you're offering a relatively low skilled wage, you're unlikely to get someone who is skilled or at least who's good at it, whatever it is you're looking for. And you need to think through the matchup of the two. And there are lots of resources out there, whether through pro bono partnership or just public organizations, that can give you some basic ideas of what certain types of people, certain types of job categories earn in your communities, so that you have an idea that you're at least in the ballpark. Now, maybe you're at the bottom of the ballpark because you're a small nonprofit. That makes perfect sense. But if you're looking for someone to do a very high-skilled thing, and you're paying as if they were doing a very low-skilled job, you're unlikely to find a match that's going to be beneficial to you in the long run. Unless you can offer that person something else that makes it worth their while to take the job and work in that position. Maybe it's just someone who's committed to your organization. Maybe it's someone who believes in your mission, is willing to do the job for far less than they can make in the market because of your organization. That's a win-win, and it certainly happens. But you need to at least think about whether that's who you need to find. Our next slide talks about the question of how are you going to find your employees? One option is to consider, are there people you already know who are interested, willing, and ready to be your employees? Are there volunteers? Are there independent contractors? Are there people you've just dealt with who would like to come work with you and do it in a more formal basis as a real employee? On the other hand, is there a reason why you'd rather not take from your inside people? Maybe you don't want to lose that great volunteer. You can't afford to pay that person what they're worth, and you don't want them to stop volunteering. So you need to go somewhere else to find someone. Maybe you want someone who has a different set of skills than what you come across in your volunteer or your contractor universe out there. If so, how are you going to find that? What resources are available to you? How are you going to reach out into the community? There are obviously formal ways like job advertising. There are online resources. There are people out there who can help you find an employee. But for most nonprofits, those aren't all that viable because there's an expense and there's a fairly low yield to what you're going to get out of that. More than likely, it's going to be word of mouth through the communities that either you serve or that you interact with. And you do want to make sure that you are casting as wide a net as you reasonably can because you want to find the best candidate for your job. And that's one of the dangers of looking only internally is you don't know if you're finding the best candidate. At the same time, you're not going to do a nationwide search in most situations because that's not practical, viable, or reasonable. So balancing the two is what you want to think through. Do we want someone we already know? What are the benefits of that? Well, we know them. We know their reliability. We know their personality. We know their history. We know their work ethic, at least to some degree, versus someone we don't know at all. On the other hand, if we open it up to the people we don't know, are we going to find someone out there who's just far and above what we would find if we look at our internal resources? So those are the things you need to think about and consider as you are saying to yourself, how do we find an employee? From a little more of a legal viewpoint, you do want to have some formality to your process. I encourage you very much to find or get a form for the application so that you're asking some basic information of the employee and so that you know you have the basics you need to consider whether this person should even be eligible to be considered for hiring. And there are a lot of things that you can get out there from whether it's from Pro Bono Partnership or other organizations or just publicly available that at least give you the basics of what you want on your employment application. You need to know the basics of who they are and make sure they are who they purport to be before you move forward with that. And think about the job. The advice that I always give is everything you're asking for, whether in an application or an interview, should be focused on how does that information help us determine whether this person is the right and best candidate for a job. If the answer to the question is it doesn't, don't ask it. Don't ask it in the interview. Don't include it on the application. That's the touchstone for the finding the person process. Everything you do should be related to, does this help us figure out, is this the best candidate for the job? And your employment application will be tiered along that way. For many of your organizations, you may have either a legal obligation or know that it's a good idea to conduct some form of background check, whether it's because you deal with money, whether it's because you deal with donors, whether it's because you deal with an at-risk population. You're going to need potentially to be able to do a background check on someone. Now, part of that is just doing the application, asking them who they are, where they live, where they've worked, and checking up on that to make sure that's all true. But part of it may get beyond that, whether it's a criminal background check or a motor vehicles background check or a financial background check through a credit check, and you're going to need more than likely some resources to do that properly. I'd encourage you to look into that, investigate that. That's not an area that you want to do without knowing what you're doing. There are some tricky laws out there potentially, and there's just some inability. I mean, yes, you can go on the internet and Google search someone, but the reliability of that information is not necessarily what you want to have as an employer. Maybe you want to Google them as well, but you probably need to, and certainly for some nonprofits, you legally need to do certain background checks of them to make sure that they can properly interact with your client base, deal with your funds, uh, work under grants or funding that you have, whatever the situation may be. And that is an area where there are professional resources, there are nonprofits like Pro Bono Partnership that can help you, and you may even want to make an effort to find legal counsel and make sure you're doing that the best and the right way. Okay. Continuing on with how do we find our employees? Do you know how to conduct an interview? If you don't, you want to look and get some resources on how to do that. There are certainly written materials, there are materials in the local library, there are professional resources from a local chamber of commerce, as well as organizations from the more legal side who can give you the basic do's and don'ts of interviewing. You may have heard through the world and through time that there are questions you may not ask and questions you must ask. Most of those things are myths. Okay? There are very few questions you cannot ask, but there are a lot of questions you probably shouldn't ask. And the reason for that, again, is you want to be focused on things that help you figure out, is this person qualified and the best candidate for the job? And a lot of questions that people might be genuinely interested in asking don't belong in the interview process because of that, because they truly don't get to the question of how can this employee perform the job best? Are they illegal per se? Is asking someone about their race, their religion, their color, their national origin, those things, is simply asking the question illegal? No, it's not. But if that information has nothing to do with whether they're a good candidate for the job or not, then why would you want to ask it? And why would you want to put in an employee's mind that that matters to you when it shouldn't? And that's a lot of what you hear in the employment world is, well, we can't ask that question. Well, you can, you just probably don't want to, and you shouldn't, because no good can come from asking a question, the answer to which doesn't help you figure out, is this the person we want to hire or not? So give some thought to what you want to ask, what you want to find out. Interviews should be planned out and thought out, not spur of the moment. If you're going into the interview thinking, I'll figure out what to ask once I meet the person, you're not prepared. You're just not prepared. You should have a list of questions or a list of topics that you're going to cover, and you should be consistent with more than one candidate if you're interviewing more than one person. So you get the same information from multiple people, and you can compare apples to apples, which is most important if you're trying to find the best candidate. And as I mentioned before, every question, everything you do in the process should be focused on figuring out, can the person perform the job? Can they do what's necessary? And are they the best candidate for you, your organization, and the job? Let's move on to the wonderful opportunity. You've now found someone. You've identified the best candidate. You've made them an offer. You've said, we want you to come work with us, and they're interested in saying yes, or they've said yes. Know about the paperwork and forms that may be needed, and consider whether you need to do an offer letter. Do you want to put in some writing, in a formal basis more than just a conversation? We want to hire you. This is your job title. This is your basic responsibility. This is your basic pay. Most employees do not have employment contracts. Very, very few, frankly, have employment contracts. You might consider, is this one of those few? Do we want to have an executive director for an organization with an employment contract? That might be the only person in your organization who has one, if that. But if they're not going to have an employment contract, you want to have something in writing, even if it's just an email, something documented about what the job is, what the obligations are, what the basic compensation is, so you don't end up in a dispute down the road over a disagreement over what that was supposed to be. What other paperwork? Is there a form you want them to fill out once they start? Basic information you want from them, contact information you might not have gotten from the employment application, things to start a file. If you're going to have an employee, you're going to have an employee file, and you need to get basic information. There may well be tax information you need, obviously, if you're going to pay them. There may be state organization information that you're going to have to file. We'll talk about a little bit of that in a few moments, some basic things you're going to need to do. But you want to get or know the checklist of what do we have to have now that we've got an employee, and make sure that you start to build that file with the information you need and start off on the right foot. And you need to make sure your organization is ready to start managing and tracking the performance of an employee, good and bad. Hopefully it's going to be all good. But just because the employee is doing a great job doesn't mean you shouldn't be tracking and managing their performance. You should be. You should be letting them know they're doing a great job, and you should keep a record of them doing a great job so that you either have that to prove if you ever needed to or just to support your actions because this employee is doing a great job, or should unfortunately it change. You want to be able to show that the employee was capable of doing the job and did the job, and now something has changed about them. And that can be very powerful information if you end up in an employment dispute to be able to have that documentation. Also, I encourage you very strongly to plan to orient the employee. You hear a phrase these days with big organizations called onboarding. You know, it's almost like the ship lowers the ramp and easily slides the people on board, as opposed to the ship sailing by the dock and saying, jump on, and off you go. That's unfortunately what happens to a lot of employees. It's like the jump on, and they're holding on to the railing at the very back of the ship trying to stay on board, as opposed to the nice ramp where they walk up and they're greeted by someone and welcomed on board and shown around the ship. It makes some sense. If this especially is not someone who's long time familiar with your organization, you want to introduce them to people. You want to teach them about your organization. You want to give them the orientation. Maybe the one that you're thinking yourself, I never got something like that. Well, okay. So do better by the next person. Give them an orientation. Get them set off on the right foot. It will make a big difference in their likely success rather than just, I'm too busy. Here's the information. Go at it. Good luck with that. It happens a lot. Sometimes it's necessary, but it's not the recipe for success. It may succeed, but it's definitely not the recipe for success. Okay, now let me put on my lawyer hat even more so for a minute and talk about some legal obligations as an employer. There are some. As a small nonprofit, which many of you are, or at least are for now, the obligations may not be as specific and concrete to you as they would be to a large organization, but I still think it's important for you to know what they are. And let me start by covering two legal terms that we hear in the employment world that so few people truly understand, and they mix up. So let me, and this includes lots of, experienced HR people who mix these up. So I wouldn't expect anybody else to know them. What does employment at will mean? Employment at will means that an employee can come or go as they please, and you can ask them to come or go as they please. They work at your discretion. If you want to let them go, you can let them go at any time for any reason as long as it's not an illegal reason. And they can leave at any time for any reason. So your essential employment relationship is moment to moment, day to day. That is the world for virtually all employees in this country. The only exceptions are those who work as part of a unionized work environment or those who have an employment contract. And that's a small percentage of all employees out there. Most employees work as at-will employees. They work at the will of their employer and their own will to show up and work every day. That's the norm. And there's nothing wrong with that. That's simply the status that we all have. You will sometimes hear the phrase right to work state. What does that mean? It means in about half of the states in a unionized environment, employees cannot be forced to join the union. So for most nonprofits who are talking, if not virtually all nonprofits, that has no impact on your organization. You're not dealing with a unionized environment, and you're not in a situation where somebody who joins your organization is going to be required to join a union. So if someone is talking about it, that you hear that they're in a right to work state, either they're totally misusing the term or they're dealing with the unionized environment. Probably the former, possibly the latter. For your organizations, don't worry about it. It has nothing to do with your organizations. What types of employment laws do exist that matter to you? Well, to put them in some basic buckets, there are laws that deal with wages and hours that employees can work. Some of those cover you, some of those don't. They vary from state to state. Here in Georgia, we have a minimum wage and hour law that does very little and affects very few people because the federal wage and hour law is at a higher level with more requirements. So the only people that would be affected by the Georgia law are those who are too small or not covered by the federal law, which are some small nonprofits, for instance. But even in those situations, rarely do you, small nonprofits, want to pay someone less than the Georgia minimum wage, which last time I checked was about $4.25 an hour. So there are very few people out there who are going to take a job, let alone that you're going to offer a job at that kind of rate. It's really a law that just doesn't keep up with the times. It's a floor, but it's a floor well below modern floor. Um, Federal law has minimum wage at $7.25 an hour, so you can see what kind of gap that is today. And even though a lot of organizations are not covered by that federal law, if they're small, if they're within a single state, if they don't have a large budget or a large income, you're going to want to consider, do we have any reason to want to pay less than $7.25 an hour? You may well not, especially for anybody who's going to add real value to your organization. But that law is out there, and there are other laws within Georgia and other states that may restrict when people can work or how long they can work or whether they're entitled to extra pay when they work beyond a certain number of hours or beyond certain days. Again, a lot of these laws don't apply to you, but you want to get familiar with them once you have an employee on board if they're working more than regular days, 5 days a week, up to 8 hours a day. You want to get familiar with them so at least you know what the employee might think they're entitled to, even if legally they're not entitled to. And certainly if they are legally entitled to it, if you are covered by that federal wage and hour law known as the Fair Labor Standards Act, you want to know that an employee is going to be entitled to overtime when they work more than 40 hours a week. And you want to know how to calculate that time and a half of their wage rate. And you'll want to know the difference between those who are paid by the hour and those who are paid on a salary simply to get the job done. And there's a distinction between those two. With your first or your second employee, those are the kind of questions you want to ask. Is this, you'll hear the phrase, an exempt employee, someone who isn't entitled to necessarily minimum wage or overtime. They're simply working to get the job done, and this is how much we pay them to do it. Or is this someone who's working by the hour to get paid by the hour? And that's the way we need to keep track of their hour pay. Those are those areas of law. And there's some other laws that come up, but not often in the wage and hour world. There are also some laws that provide certain protections and limitations, whether they're about a safe workplace or they're about certain things employers can and can't do or must not do with their employees. Again, most of those apply to employers that have at least a handful of employees. Many of them apply to employers that are quite large. But there are things you want to be aware of. You want to make sure that you maintain a reasonably safe working environment. If there are hazards there, if there are dangers to your employee or employees, that you do something to try to address them. Even if the law doesn't require you specifically to do that, it's simply the right thing to do. How does it possibly benefit your organization if your employee is harmed in doing their work in a way that you could have prevented or should have expected, and now the employee can't work because they've been harmed? Not a beneficial situation to be. The last area of the law are a group of topics, the non-discrimination laws of the world, that say we as a community think that certain categories, criteria, things like that should be off limits for employers to consider. We all generally know that you can't make employment decisions based on someone's race or religion or national origin or sex or categories like that. The truth is, you can if you're a small enough employer in most states. In Georgia, the federal law covers employers with 15 or more employees, and in Georgia, most of those areas don't have their own state law. So you can, as an employer, if you wanted to, make some decisions like that. But I'm here to tell you, you don't want to. The reality is you should always be focused on finding the best employee. And those characteristics, those categories have nothing to do with an employee being the best candidate for the job. It's an exceedingly unbelievable rare circumstance where any of those things truly matter to an employee's ability to do the job. So not only is it not what our communities accept as far as employers making decisions, not only is it illegal for most employers, it's bad business and it's a bad idea. So what I suggest is that even if you're a one employee nonprofit, while you may not be legally obligated to have a non-discrimination policy, why would you want to make a discriminatory decision in hiring an employee or treating an employee? There's no upside or benefit that you can readily see. There's plenty of downsides. And even if you ultimately might be able to defend yourself in a claim for discrimination because you'd say, I'm not covered by the law, I'm too small, what good does that do you to have that battle in the first place. So most people are generally familiar with those areas of the law. It's worth making sure you're fully familiar. And you try to recognize the laws that apply to larger employers, and to the extent that you can, you apply them to your own organization. Now, sometimes there are laws that are just not practical for you to do. A perfect example is the Family Medical Leave Act. It's a law that provides certain amounts of time off for larger employers, those with more than 50 employees. Obviously, if you've got 2 employees, giving an employee an extended period of time off may not be practical or possible, that it might be if you had hundreds of employees. So that law won't apply to you because you're too small if you have less than 50 employees. And that's an example of when you may simply say, look, we wish we could comply with a law like that, but we simply practically can't. But most of the areas of these public policy laws, you may not make employment decisions on the basis of someone's race or gender or religion or other things. Every employer can comply with if they choose to. And they're highly beneficial to the workplace and the community and the environment you're in. Moving on to our next slide, just continuing a little bit of discussion about your obligations as an employer. As I said, there are lots of laws that exist. Most don't apply to you, but they're good ideas to follow through on. I've talked about the non-discrimination, non-harassment ideas. Fair treatment, fair and regular pay. Even if you're not obligated to do that, you're going to have a better experience with even your single employee. If you treat that person well and fairly, you pay them regularly as you say you're going to do, and you treat them as you would want to be treated, or as they would want to be treated within reason. And consider some version of performance management, giving them positive and negative feedback. Employees generally want that. Most employees want to do a good job. But in order to know they're doing a good job, somebody has to tell them they're doing a good job often. They don't maybe know it themselves. Flip side, of course, is if they're not meeting your expectations, you want to let them know that. You want to give them a chance to improve. You want to give them specifics about how they can improve, so that if they don't improve and you're in a situation where you need to discipline or worse, get rid of them, you can show that you made a reasonable effort to correct the situation before you had to go to the ultimate decision of letting them go. Is it legally required you walk through all those steps? Perhaps not. Is it a good idea? Absolutely. Hopefully, you can fix the situation, which is the best case scenario. If you felt like this was a good employee, they had all the skills and abilities when you hired them, and something's happened where they've gotten off track, getting them back on track is a lot easier than going through the whole process again and finding someone new. And if they won't get back on track, or they can't back on track, or they're simply not capable as you thought they were to do the job, then at least you've established that by giving the opportunity to them to show you that they can do it. And they've now shown you that they can't. And you're an ability to be able to say, I'm sorry, we need to part ways. My experience tells me that when you take an employee and you manage that employee positively and negatively, if things don't work out at the end game, most employees will see it. Most employees will understand it. They may not like it, but they will see it and understand it. If you haven't given any performance management, they will view it as a surprise, as unfair, and their mind will go to other possible reasons why you're doing this of unfairness. They won't think it's them, they will think it's you. And you want them to know it's them. This is not the situation for you to say to an employee, it's not you, it's me. You're great, we just don't want you anymore. You most situations want to be in a situation where you can say, we thought you'd be great. We gave you every chance to be great. We told you when you weren't great and asked you to please be great, and you were unwilling or unable to be great. And so that's our expectation. You know and we know that you're not meeting our expectations. We've got to find someone else who will, and we've got to part ways with you. And even as a single employer nonprofit, you're in a much better situation having done that than you are trying to pull the it's not you, it's me, but we still need to part ways. That doesn't work well in personal relationships, and it doesn't work so well in employment relationships either. I want to touch on a couple specific legal obligations that employers in Georgia do have to deal with, and even in many cases, small nonprofits. The first one is unemployment insurance. You may well know that you're exempt if you're a small nonprofit, or even maybe a larger nonprofit in some cases, from federal unemployment taxes. But in the state of Georgia, that's not always the case as well. First, all Georgia employers must register with the State Department of Labor as soon as you make your first payroll to even a single employee. And a lot of employers don't know that because they think, oh, unemployment taxes only come in when I have a certain number of employees. And that's right. But you've got to register with the Department of Labor once you have a single employee. If you get to the point where you have 4 or more employees, which can include an officer or director, even if you don't think of them as an employee, once you get to 4 or more employees who are working in each of 20 calendar weeks or more a year, that's when your obligation to pay state unemployment taxes comes in. So that's something you want to look at as you go from a single employee to anything beyond that. When do we hit that obligation to pay state unemployment taxes? There are 2 different ways you can pay state unemployment taxes. They mention them here, contributory method and reimbursable method. We could spend 15 minutes talking about those because they're a little confusing, I think, and I'm not going to cover them, but I want you to know there are different ways you can pay state unemployment taxes, and you should be educating yourself on that. The Pro Bono Partnership has a wonderful piece. It was educational for me, quite frankly, on the difference between those 2 ways to pay your state unemployment taxes and the pluses and minuses of those. So what I'd encourage you that as you get from 1 employee towards 3 or 4 employees, you realize, okay, state unemployment taxes are going to be something we have to deal with. If you haven't already, you should be talking to them about what are our different options for dealing with this. That's our information on unemployment insurance. I want to move to our following slide on Georgia workers' compensation law. Briefly, just so everybody understands workers' compensation law, it's a concept that we want to create a no-fault system, meaning if an employee gets hurt at work because of their job, they're covered. They get some benefits and recovery for their harm. The trade-off, and this is what's very good for employers, is they can't sue you for their personal injury. So if an employee falls down at work, instead of them filing a lawsuit against you because your rug was worn and it was a slippery, trippy spot, they get the recovery through the workers' compensation system. It's reasonable, it's fair, but it's limited, and you don't have to deal with a lawsuit for their personal injury. And that's the reason the system exists. Employers with 3 or more employees must maintain workers' comp insurance. Okay? And interestingly, in Georgia, corporate officers are counted as employees, although some can opt out. Up to a certain number for smaller organizations can opt out. So you might be in a situation where you have less than 3 employees, or even 3 employees and some corporate officers that add up above 3, but you could opt out by those corporate officers saying, we don't want to take part. Go on to the next slide and point out that actually any employer of any size in Georgia can voluntarily elect coverage by purchasing workers' comp insurance coverage. You might be thinking to yourself, well, why would I want to do that? If I don't have the minimum number of employees or my officers and directors opt out, why would I want to do that? You may not, but you may. And again, that goes back to that exclusive remedy. Which would you rather do? Would you rather pay a set amount for workers' comp insurance and know that you're covered if one of your employees gets hurt as part of their job? Or would you rather stay out of that system because you're quote unquote too small, and if somebody gets hurt at work, they can sue you and sue you for their personal injury? They fall backwards in their office desk chair. And you think, well, okay, we don't have a dangerous workplace. We have an office environment. Well, someone leans back in their office desk chair and they fall back and they hit their head and they hurt themselves very badly. Scary thought. Could happen to anybody. You've got a workers' compensation insurance coverage policy. Their medical bills, their injuries, your exposure are limited to the cost of that coverage and the benefits of that coverage that go to the employee. You don't have workers' comp and that employee chooses to sue you saying that you knew the chair was dangerous or whatever the situation that you might be liable for. It's a wide open possibility. Now, you might win that lawsuit and prove to a jury that that person was being risky by leaning back in a chair with wheels. But do you really want to go down that road? And a lot of employers don't. So it's worth looking into workers' comp insurance if you even have a single employee. Even though it's not required until you get to 3 or more, it's worth looking into. And for a lot of small nonprofits, the cost is very manageable. It just depends on what your budget is and who you're dealing with. Last 2 slides on workers' compensation go through very briefly, but just so you know, it does cover the benefits of an employee. the medical benefits, the lost pay, those kinds of things. So you're getting some bang for your buck on behalf of your employees if you have the coverage. And it covers any injury that quote unquote arises out of or happens in the course of their employment. It's intended to be very broad, short of something that has nothing to do with their job. If they get hurt while they're working at work, doing something work related, it's more than likely going to be covered. And there, then it's the exclusive remedy to the workers' comp system. Last couple points on workers' comp on our last slide. You should try to keep your workplace safe. I mentioned that earlier, because obviously, even if you have insurance coverage, you don't want to have to use it. Just like we all might say, just because you have auto insurance doesn't mean you want to drive into a tree. You know, it's nice to have the insurance, but you don't want to use it if you don't have to. Keep the workplace safe. If you've got that wobbly chair that people have fallen over on before, get rid of it and get a more stable chair, okay? You don't want people to be hurt. If you have workers' comp coverage because you're more than 3 or more employees, or even just because you choose to, there are some obligations of things you should do. You should post what's known as a panel of physicians in the workplace. It's really just a listing of doctors that the employees can go to through the system and be covered rather than running to their own doctor. That's beneficial for everybody. And you should encourage your employees to report any kind of workplace injury or illness immediately. Georgia workers' comp law gives employees up to 30 days to report an injury or illness from work. But employers certainly can ask their employees to notify them directly and immediately, and they should. Because if you've got an employee who hurts themselves, you want to know because you want to get them medical care, and you want to make sure they don't hurt themselves worse by continuing to work. So you need to know, and you have a right to ask employees to notify you immediately. If they fail to, they might still have benefits and coverage, but now they're violating your rules and your policies, and you want to address that. Okay. There's a form that you would need to fill out, and it's referenced in the slide. It's available on the various websites. It just simply covers the information of the injury. Okay. Want to get to my last couple of slides before we finish up and leave a couple minutes for questions if there are any. Some other legal considerations. You may have heard the phrase wrongful termination. Generally, there is no such thing in Georgia. From the context that employees are at-will employees, unless they're in a union or they're covered by a employment contract, you can fire them for any reason or no reason at all, as long as it's not an illegal reason. In Georgia, there really has to be some statutory protection, some law that says, employer, you may not fire the employee for this particular purpose. And I'll throw out some simple examples. Jury duty, time off for voting, military service, reporting something to a government agency or raising a complaint with a government agency. Those are the kinds of things that you may not be able to discipline or fire an employee for doing. And if you were to do that, that would be the quote-unquote wrongful termination. But generally what people often say is that's unfair. They can't do that. That's wrongful termination. It's not about fairness. In an ideal world, as an employer, you'll be fair. But they only have a legal claim if you've done something that violates a law. And simply being unfair doesn't violate the law. That's helpful for employers to understand. In a perfect world, you'll never have anybody leaving thinking they've been wrongfully terminated. But that alone doesn't do it. There has to be some legal obligation to do something or not do something that you violate. Last slide, let me give you some tips on what I think are some helpful practical ways to go about being an employer. Communicate with your employees and set the expectations out for them clearly. What to do, what not to do. What are problems, what are good things to do. The better you communicate, the better you set expectations, the better employees can and will follow them. And the easier time you'll have with an employee who doesn't, because you'll be able to show that they knew what they were supposed to do and they didn't do it or they refused to do it. Give your employees regular feedback, positively and negatively. Formal feedback is great, but even informal feedback. Every employee appreciates a pat on the back. Maybe not literally, but at least figuratively. Good job. Thank you. Those are powerful words. And so are, we need to talk about something because you're not meeting my expectations. Those are also powerful words too, because you make clear where the employee stands with their employment. And like I said, most employees want to do a good job. As an employment lawyer, we spend about 95% of our time dealing with 5% of the employees that aren't really always trying to do the best job. You probably don't encounter that many of them. You will encounter people, by and large, who want to do a good job. and give them the opportunity to do so by giving them positive and negative feedback. Try to be consistent, try to be fair, and try to be professional. If you're having a bad day, if you're upset, if you're emotional, maybe that's not the best time to give your employee a performance review. Okay? Uh, Maybe if they're having a bad day, it's not the best day for you to give them their performance review. Think about those things. Be a professional, be fair, and be consistent. Treat other people the way you would treat this person, and vice versa. Um, and I want you to think about the two rules. One you may have heard of, one you may have not. Most of us have heard of the golden rule. Do unto others as you would have done unto you. That's a wonderful rule to live by. But in the employment world, it's not always okay. Because just because something would be okay with you doesn't mean it's okay for your employee. You might not mind that. You may be okay with a boss that likes to yell at you because you don't mind being yelled at. That doesn't mean the employee likes to be yelled at. So I offer to employers to consider what I call the platinum rule. Do unto others as they would have done unto themselves. Know your employees, and within reason, try to treat them the way that they would want to be treated. Not just the way you would want to be treated, but the way they would want to be treated. So just because it's okay with you doesn't mean it's okay with them. And if you think about what you think would be okay with them, this is a more sensitive person, this is a more thoughtful person, this is a more technical person, then you'll have a better effort communicating with them and getting information across to them. The last point for employers is consider and think first and act second. I, as an employment lawyer, occasionally get the call that says, "Hey, Evan, we just fired someone. Was that okay?" I can help them, but there's a lot less I can do for them than when they call me and say, "We have a problem with our employee. Can you help us walk through the situation? We may get to the point where we have to let them go. We want to make sure if we get it, we've gotten there the right way." And that's powerful. So plan and think and consider. Don't act impulsively. And there's almost no situation where someone needs to be fired right this second. Send them home. Sleep on it. Think about it. Bring them back in the next day to talk about it. And if they still need to be terminated, so be it. But pause and think and reflect and make good decisions. Okay. There's no need to be hasty with these kind of things. There are lots of ways to deal with bad situations without doing something instantly on the spot. Let's say you've seen someone do an incredibly awful thing that is perfect grounds for their termination, and you know you can't have them anymore. Do you need to fire them on the spot in front of all the people that are around them? No, you don't. All you need to do is remove them from the situation. Hey, I need you to come over here. I need you to leave. I need you to come back tomorrow. I need you to go back to the office. I need you to do whatever to safeguard that situation, and then address it once you've had a moment to cool down or to gather all your facts or to make sure you know exactly what happened and that the right thing to do is to end the relationship with the employee. And that makes for far fewer employment problems, even for the smallest organizations down the road. So I encourage you to do that. If there are any questions, I'm happy to take any. I don't know if we have any questions. It's a lot of information I've thrown at you, I'm sure. I would encourage you to seek out more information from Pro Bono Partnership of Atlanta. They can find you a lawyer like me or someone experienced in whatever area you're dealing with to give you specific guidance and information. I, for example, have worked with Pro Bono Partnership a number of times when one of their clients calls and says, "We've got a difficult situation with an employee. We're not sure what to do, or we need to move to termination, and we'd like some help." And that's exactly what an employment lawyer that Pro Bono Partnership can find you can do for you and can help you so that you can move on to finding a better employee or getting rid of the problematic employee or getting out of the situation that you're worried about. So I would encourage you to do that. We're taking a look to see if there are any questions that anybody didn't get answered. But I think we're okay. I wish you all the best of luck. I thank you for the work that you do in working for nonprofits around Atlanta and the greater community, and I wish you all the best of luck. Thanks very much.